Americans. We do not seek to minimize the harm they have experienced by being here today or to cause more harm. No one should ever go through what they have endured. Byron Black has spent decades in prison for the Clay's death, and he will continue to be held accountable for as long as he lives. At the same time, both our state and our nation have made clear that executing those with intellectual disability is prohibited. In its 2002 Atkins decision, the U.S. Supreme Court banned the execution of an unusual punishment under the Eighth Amendment. In its 2014 Hall decision, the U.S. Supreme Court affirmed its position that the execution of people with intellectual disability violates the Constitution, while also clarifying that adaptive behavior evidence beyond IQ must be considered when determining whether an individual has intellectual disability. Then, in the 2019 Moore decision, the Supreme Court further confirmed adaptive behavior criteria as necessary in determining whether someone meets diagnostic criteria for intellectual disability, and noted the modern clinical and scientific understanding of intellectual disability. To summarize, for decades, the courts have ruled that executing an individual with an intellectual disability is in violation of the United States Constitution and the Tennessee Constitution. Our state's Constitution affirms that we do not execute people with intellectual disabilities, quote, because such executions violate evolving standards of decency that mark the progress of a maturing society, are grossly disproportionate, and serve no valid penological purpose in any case. In 2021, the Tennessee General Assembly recognized that Tennessee's standards for determining intellectual disability were inaccurate and did not align with the modern clinical understanding of intellectual disability. The legislature then overwhelmingly voted to ensure that Tennessee was compliant with the current medical standards required by the courts to protect those with intellectual disability from execution. Mr. Black was tested under the state's current standards for intellectual disability. The state's own medical experts agree Mr. Black demonstrated all three of the criteria: sub-average intellectual functioning, adaptive deficits, and onset during development. Based on the new information, the Davidson County District Attorney agreed that Mr. Black is a person with intellectual disability and should not face execution. But because Mr. Black's attorneys were diligent in presenting his intellectual disability to the courts back in 2004, shortly after the Atkins decision, under Tennessee's previously inaccurate standard for intellectual disability, a judge ruled in 2022 that Mr. Black has already had his one opportunity for a hearing back in 2004. Nothing about Mr. Black's intellectual disability has changed, only the legal understanding of his condition based on sound science. If Mr. Black were on trial today, he would not be eligible for the death penalty. I think that bears repeating. If he were on trial today, he would not be eligible for the death penalty. If his lawyers had not sought a hearing for him in 2004, the court would consider the evidence of his intellectual disability, including the state's stipulation, under prevailing standards. Timing should not dictate if this man lives or dies. Governors were given the power to commute sentences for just such a case as this. The courts and the legislature have set standards to protect those with intellectual disabilities from execution, and Mr. Black's ID is undisputed. If the court will not allow Mr. Black to have a fair hearing based on the medically accurate standards of today, then the governor must intervene and commute his sentence to life to ensure that Tennessee does not execute a man with intellectual disability in contravention of the law, the values of Tennessee, and our common decency. Thank you. I'm going to hand it off to Donna.
Thanks, Zoe. I'm going to try not to cough during this. My name is Donna DiStefano. I'm grateful that all of you are here today. Over the past 40-plus years, I've worked as a direct support worker and a teacher of children and adults with disabilities. And also, I've been an advocate for people with disabilities. The experts and the law have established that Mr. Black is unquestionably a person living with an intellectual disability. Throughout his life, Mr. Black's intelligence testing has consistently been in the range of intellectual disability with a Flynn-adjusted IQ scores ranging from 52, 67, 67, and 70. He has adaptive functioning deficits in language, math, money, and self-direction. Neuropsychological testing indicates his math abilities fall in the second percentile of reading and in the fourth percentile. This means 98% of others are better readers and 96% are better in math. And recent testing confirms that Mr. Black has severe impairment in applying situation. He never lived independently, even after marrying and fathering a child, and he could not perform simple tasks like cooking or operating a washing machine. His academic difficulties were apparent as early as the second grade, when he was held back due to poor performance. Further evidence of early onset intellectual disability includes his inability to play simple games because he couldn't understand the rules, and his inability to remember how to perform his chores. In addition to his intellectual disabilities, Mr. Black is now elderly, he has dementia and brain image, which further limit his cognitive abilities. There's no dispute about Mr. Black's intellectual disability. The evidence is overwhelming. I believe in many ways our state is a leader in protecting these vulnerable individuals, including when they come into contact with the criminal justice system. In fact, Tennessee was one of the first of 4 states to protect those with intellectual disability from execution when our legislature did so in 1990. Governor Lee, if there is ever a time for executive to bestow mercy, it is to ensure that Tennessee does not knowingly and intentionally violate the law by executing a man with intellectual disability. Thank you. And I'm turning it over to Sarah Sampson. Oops.
Hi, I'm Sarah Sampson, and I'm the Executive Director of the Tennessee Disability Coalition. We are an alliance of individuals and organizations joined to promote the full and equal participation of Tennesseans with disabilities in all aspects of life. In 2021, we championed a bill at the Tennessee General Assembly to modernize the definition of intellectual disability in the criminal code and create a pathway for folks already on death row to go to court about their intellectual disability. We are grateful to the 112th General Assembly that passed that law, and it's why I'm here today. The Tennessee Disability Coalition has joined with the ARC Tennessee and Disability Rights Tennessee, who also serve Tennesseans with intellectual disability, to sign on to a letter to Governor Lee asking him to commute Byron Black's sentence to life because of the legislation in place and because of the Supreme Court and Tennessee court rulings. I will read a passage of that letter, and it's also available in hard copy on the chair over there and online. From that letter, medical experts, including the state's own medical experts and the law, establish that Mr. Black is a person living with intellectual disability. If he was tried today, he would not be eligible for the death penalty. We extend our deepest sympathies to the victims of his crimes and their friends and families, and we do not absolve him of this crime. We are here about the law that is in place today, and it is based on that we are asking Governor Lee to commute Byron Black's sentence. We're asking Governor Lee to reaffirm that Tennessee does not execute citizens with disabilities, intellectual disabilities. Thank you.
Now we will open it up for questions if anyone has any. I do want to preface that offer by saying that none of us are attorneys associated with the case. We're here as advocates on behalf of a man with intellectual disability, pleading with the state to stop the execution. We also, as community members and residents of Tennessee, we want to live in a state that prioritizes the humane and dignified treatment of people with disabilities. And really, the state has done everything in its power up to this point to pursue those values and to demonstrate its intent to avoid execution of people with intellectual disabilities. Unfortunately, we've hit a procedural hiccup, but thankfully, the governor has the ability to remedy that hiccup with his commutation power. So I say all that and open up for questions if there are any.
I know this would be like a very long, detailed answer if we got into it, but could we like ballpark, very big picture, talk about how our understanding of intellectual disabilities has evolved over the past few decades?
Sure. I think in terms of assessment, I'll speak to that a little bit. Prior to us adopting the current standard that looks at not just intellectual functioning, but also adaptive behavior deficits and early onset during childhood, we were just looking at IQ tests essentially. And as you know, when we know better, and we know better about intellectual disability. We know how it presents. We know, what to look for beyond just that intellectual assessment. And so that's sort of ballpark how things have shifted. And I don't know if Donna or Sarah wants to add anything to that.
I'll just do one. I mean, basically, over the years, because people with disabilities and people with intellectual disabilities have been treated as non-entities. So when you treat it as a non-entity, you're not really looked at. So a lot of what we don't know, there's a lot of people that weren't right, as my family used to say, that probably had an intellectual disability. Over the years, we began to learn how to make assessments on people, and to do that better over time, and to become better experts at the testing. We have done that. We're continuing to do that. So things evolve, over time. And what we knew way back and what we know now are very different. And just the IQ score alone, I mean, you know that there's been so many issues about just IQs in general. So that's one factor. So put that as one factor, but then the whole adaptive behavior and adaptive functioning, the fact that people may not know how to operate a washing machine, may not be able to understand the rules of a game, those kinds of things get pulled in as part of the assessment and are treated as part of the overall and more holistically. I hope that helps to explain it.
I think so. Thank
Okay.
you.
Anything else?
What would be your message to Governor Billy if he's to watch one of our stories?
I think the message would be that Tennessee has made it clear that we don't execute individuals with intellectual disability. And unfortunately, there is a procedural issue when it comes to the facts of Mr. Black's intellectual disability and the timing at which it was presented to the court. And so our message would be that he really has an opportunity to make things right here and to use that commutation power in the very sense that it was intended. Anybody else? Okay.
Okay.
I think that's it. Thank you all for coming. We
you.
appreciate it.